what are the experiences of some real practitioners in terms of dealing with limited scope retainers and alternative fee arrangements? And we're going to turn to Elizabeth first of all to share her comments with you.
Thank you. I am really glad I listened to Chris Bentley speak today, because he's got me thinking that I'm on the right track. I've geared my practice. I'm a family law lawyer. I've been a sole practitioner for 24 years. And at the start of 2016, I opened something called the New Family Law Center, which is a company I run in addition to my law practice. And I gear things towards middle income families, and I've heard that defined, I've seen on government websites. It's a family income of $160,000 or less. It sounds like a lot of money when you get up to $160,000, at least to me. But you know, when you start getting billed $450 an hour or $600 an hour with no sort of structure to it. Sorry, if you couldn't hear me, I apologize. With no sort of structure to it, it becomes overwhelming extremely quickly. So in my private practice, I have 2 alternative fee arrangements in place. It's dead simple, but you really need to have excellent practice administration to do it, and that's your responsibility in my submission. Chris mentioned some statistics presented by Clio. What I saw recently from Clio on Twitter is that they've calculated that lawyers tend to collect 86% of every dollar they bill. And to me, I would say that you're probably doing excellent work that adds value to people and that you deserve to be paid for every single thing you do. You should have 0 receivables year after year. So in terms of alternative fee arrangements in my private practice, I do 2 things that are options. One is a fixed fee plan. So it seems to me I spend 2 or 3 hours on each file per month, and I've calculated what I need to receive on a monthly basis to keep up with the work that I'm doing. So initially when I put that plan in place, I based it on 2 hours. I'm leaning more towards 3 hours, but it allows the client of modest means to pay a really modest retainer. I take just $1,000, and I take a series of post-dated checks commencing 30 days from when I'm retained. So X amount 30 days from now and every 30 days thereafter. It's very easy for billing, you know, for the meeting the rules and obligations. I'm billing for work I've already done. Got no problem. Every single month I diarize billing that person for that fixed monthly amount, cashing the check, have a look to see if I have an adequate supply of checks going forward. The invoice is delivered to the client, marked paid in full, and we just keep going. There are some months things are a little busier and you might feel that you're getting behind, but compared to what you would bill if you were docketing your time the normal way. But there are months when the file slows down and you're still billing that amount. So in my experience, over the course of time, it's quite a satisfactory way to be paid, and it's very predictable for the client. And just for guideline, I really do suggest you lean somewhere between 2 and 3 hours, just so that you don't find you do your first file that way at a loss. The other monthly payment plan I have in place is just hourly billing, but with a fixed monthly payment. So on cases where it sort of feels like we're overcharging, you know, maybe things aren't that complicated, and a client doesn't want to commit to a fixed amount per month, we can bill hourly. So again, I take a very modest retainer. That's designed, that $1,000 retainer, is just to cover me for disbursements or if a check bounces or is missed, right? I don't want to be holding the bag. But I carry on billing hourly, and either that monthly payment goes to satisfy the bill, or it goes into trust if there's no account payable. And the retainer can just build up again, but the client knows this is what I need to pay, this is what I need to set aside. And I find my clients of modest means do the best job paying. They're very aware. They don't want their checks to bounce. They know what they have coming due in the month. It's my higher income clients that tend to let things slide. So I've been very satisfied with these arrangements. And it gets more people in the door. It's a lot better than trying to get someone in an initial consultation. I heard this yesterday for someone I was doing some limited retainer work for. I was just helping them draft court documents. And we wrote that out and he signed, and that was fine. It was very clear what I was doing, but he had had an initial consultation with someone through the Family Law Center that will set up, I'm the new Family Law Center, they will set up a consultation for you. He spent $400 on the consultation, didn't get help with his forms, he really wasn't clear about anything, and he was asked to make a $20,000 commitment through the course of the year for what he did not know. It's a whole lot easier to speak to someone and say, we can get started, I'm looking for a $1,000 retainer and a series of post-dated checks. It's a much easier conversation to have. I'm going quickly just because we're behind, but the New Family Law Center is my company. It's not a law firm. And in the company, I provide full legal representation for separation for a fixed fee. So my goal was to be able to tell people what is this going to cost and how long is it going to take. And I wanted to be able to get a separating couple on a parallel track, you know, to avoid all the delays that happen in family law files when you're just parked at separate law firms with no coordination. And I mean, I saw what collaborative law was doing, but I also saw that that was uncoordinated. And there just needed to be a solution to get people on the same track. So what I did was I've assembled a panel of independent lawyers. They're 20, 30, 40 years experience. They've all signed memorandums of understanding with me. And when a couple comes towards the New Family Law Center and says, we want to go through this in a peaceful way, they finally have an option where they can get on the same path. They're each provided with their own lawyer by the center, but on my terms. So the terms I put together are a 16-week start to separation timeline, or start to separation agreement timeline with full financial disclosure. So a fully documented financial statement, a fully documented FP statement, a settlement meeting with an evaluated assessor in it, and a separation agreement prepared for, you know, all of the issues that have been resolved. So they're on my timeline. They have a code of conduct between the lawyers and towards the clients. The clients have their expectations spelled out in terms of how they're going to behave. And that lawyer has agreed to accept a flat fee for the work. So everyone's very relieved that they can speak to their lawyers without being billed by the minute. And what I have experienced as I've approached lawyers to be on my panel is that everybody says yes. And the interesting thing, I think they're just interested to see if the process works. It sounds like a better way to do family law. They're getting clients that they didn't have to go out and earn by promoting themselves or anything like that. They're not taking cold calls all day. They're just getting a call from me saying, would you like to do this one? And they know that they're guaranteed payment because I don't make that call until the New Family Law Center is in funds. And once the parties are placed with their lawyers, they're getting full independent representation with this structure. And the New Family Law Center just supervises the timeline. And I roll out video wellness programming on stress reduction, just that I had a psychologist made, to both parties just to set a tone. So I think I've checked some boxes that Chris mentioned about being simpler and faster and more affordable. It's not about technology, it's pretty low tech, but it's practical and it's working. And I wanted to share that with you as well.